Mr. Becker.
May it please your lordship. If I just go back to figure 2 and then move on to the alternative embodiment. Figure 102 in the patent, box 106. At box 104, we've taken the converted measurements into some adequate GSM signal strength. And then 106 now tells us compare the converted UMTS values with GSM values and send the best values in the standard GSM measurement result message. So all that's in 106. When we go to the text of the alternative, we go back to page 4 of the patent, line 7. And we're told alternatively at step 106, instead of comparing the converted UMTS measurement values with GSM measurement values, the mobile can convert to an appropriate GSM value and select each measurement value that exceeds the predetermined signal strength threshold for reporting to the GSM. Several points. That's the only reference to threshold in the entire patent, apart from the claim, of course. No further explanation of where it comes from. In this alternative, you're not told to use a standard GSM report. That was step 106. And this is the alternative to step 106, where instead you're just told to use the threshold to select what could be an unpredictable number of values for reporting. And when I say unpredictable, it obviously depends on how high you set the threshold. If you set the threshold too high, you may get none at all. If you set it just right, but you won't know at the time you set it, you may get exactly 6. If you set the threshold too low, you get more than 6. And it may be, in some embodiments, you might want to apply some other means for limiting the number you send, but that's not actually what the passage here is telling you. It's telling you that instead, as an alternative to step 106, instead of making inter-rat conversions, you simply compare with a threshold. What it's not telling you to do is to put them in the same envelope. That is to say, the same GSM message format. And even if you think you might want to do that, the claim certainly doesn't require putting them in the same GSM type measurement report. It just says here, select them for reporting, and you can therefore send them to the base station in whatever way you like. So contrasting the two approaches, the first alternative requires GSM and UMTS values to compete with each other to pick the best 6. There's a competition going on for those 6 golden places in the GSM measurement report. The second one is very different. There is no competition between rats at all. The UMTS values are instead assessed against a threshold, and GSM measurements are irrelevant to that. The threshold can come from hardwired in the mobile, calculated in the mobile, sent by the network. The claim is that the patent is entirely indifferent as to that. If they exceed the threshold, they're selected for reporting. And then moving on, paragraph 17 tells us that in accordance with the preferred embodiment, so this is the preference point again, they can be converted to GSM measurement format. This appears to be discussion of the first alternative, where we are told that they should be placed in a GSM standard measurement report. And
I don't quite understand that. It says using the above described method 100, and when we look at the figure, 100 is the whole thing.
It is the whole thing, but it's the whole thing of the first embodiment. 100 is, if you like, lines 1 to 7, and the alternative at 7 to 10 is an alternative approach to that approach at 100. In any event, this is a preference rather than a mandatory requirement. And then the patent concludes with the usual boilerplate about the invention is capable of numerous rearrangements and so forth, paragraph 18. Lord, turning to the judgment at this stage, I'll take us, I hope, relatively shortly, because the real issue is construction of the claims. But we say that the judge reached incorrect conclusions on his understanding of the second embodiment, which then coloured his construction of the claims themselves. And picking that up, first of all, at paragraph 61 of the judgment. He quotes at 61 the first part of paragraph 14 of the patent. And then at 62, principle by order for phone to convey, the UMTS measurement information is, inverted commas, converted. Well, my complaint about that paragraph is that he's left out the word preferably, which is what the patent actually says at paragraph 14. So he's quoted the first half of paragraph 14. Then he's tried to summarise. He's then quoted in part in inverted commas, but the word preferably has come out. And that does, we respectfully suggest, change the meaning from turning it into a mandatory requirement rather than an optional feature. Well, moving on, paragraph 65, we agree with the first sentence. This equation is concerned with making the measurements comparable rather than with mapping and formatting. Well, that's right, and the whole of paragraph 15 is so concerned. And as I've shown your lordship, when we turn over to paragraph 16 of the patent, we're then told about, it then talks about the converted values, the ones that have come from paragraph 15. Well, we agree with 65. He discusses it can be done in other ways, but the point remains that it's concerned with comparability rather than with formatting. Then he reviews the alternatives. In paragraph 74, he picks up what he saw as a dispute between the parties. At 74, I now need to address the dispute between about the second alternative. Optis submitted the only difference is the comparison step, otherwise the two schemes are the same, and he deals with that. And at 75, Apple submitted that once the comparison with the threshold had been done, there was no teaching that UMTS measurements were sent in a standard measurement result message. And so he perceives that as the difference. Optis say that it has to be in a standard measurement. Apple said there was no requirement. But I can skip on this one because he gives some reasons. But at paragraph 80, he effectively concedes our point. And I'm referring to the last sentence of paragraph 80, where he introduces the end of paragraph 16, and then he says the reader would not think that using the standard DSM report was mandatory, but nor would they think that the second alternative excluded any such thing. Now, this is precisely the point that Apple was seeking to make. In other words, that you could do it if you wanted to, but you didn't have to. Optis's argument, which he summarised at paragraph 74, was that you must use the standard GSM measurement report. But the concession the judge makes at 80, last sentence, is that the standard GSM report, the reader wouldn't think was mandatory. It's simply an option. And with respect, we agree that he's actually come round to our construction of paragraph 16 rather than Optis's. And the rest of this page are essentially similar. At 78, he says one must read the document as a whole. He says overall in specification, conversion is described as one exercise, albeit it has two aspects, comparability and format. With respect, we disagree. We say that conversion for comparability is the paragraph 15 and box 104 point. And formatting only arises when you report in box 106 or in paragraph 16. And so he refers to preferred embodiments, but this paragraph 78 is therefore in itself not consistent with the last sentence of 80. stepping back at paragraph 79, 4 lines from the end, a skilled person would appreciate there were various ways of carrying this out. That could include providing that up to 6 UMT measurement reports would be included, or provide some other form of partitioning. And the word could is the key to this, rather than must. And that's all of a piece with paragraph 80. And then, finally in this section, he quotes, he refers to Mr Simmons in cross-examination. Actually, Mr Simmons's position was that the patent doesn't mandate the GSM format. My friend has quoted it in his skeleton. I'm not going to turn it up now, I don't need to. The correct approach to construction, as the judge said, is to understand what the skilled person would understand the intention of the writer to have been. Well, that's the last sentence of paragraph 80 again. And with respect, our evidence, insofar as evidence is admissible on this point, was all of a piece with what the judge had said. So, finally, on this section of the judgment, paragraph 83, the judge now moves on to the submission made by Mr Speck for Optis, describing the invention as enabling the phone to flexibly and intelligently allocate a limited signalling capacity. And then he says over the page, this is correct to the extent that starting with a standard GSM measurement report, which can include 6 cells, but doesn't enable more cells to be, this doesn't enable more cells to be reported, but it does allow the phone to select, choose the best 6 and flexibly allocate space to those 2. As we'll see in a moment, none of that's in the claim at all. These are advantages of the first preferred embodiment. They're all focused on GSM UMTS, they're focused on choosing the 6 best, and they're not focusing on the use of the threshold. So this submission as to what the invention enables is with respect nothing to do with the invention as claimed. It's what the first embodiment, which is unclaimed, is. And well, I'm now going to move on to make that good, if I may. Well, we set out the claim and a breakdown of it in our skeleton at page 9. It's probably easiest to pick up my next few submissions from the skeleton. Page 23 of the bundle, page 9 of the skeleton, paragraph 43. We've picked up the judge's breakdown into steps A, B, C and D, and with a little bit of emphasis on converting values for reasons that will become apparent. We then paraphrase the claim, and hopefully to make it take out some of the verbiage which is perhaps distracting, into 4 bullets. Take measurements in the first, the potential target rat. In the example, that's the UMTS one, the potential target. Second, convert them to measurement values for the current rat. That is, in this example, GSM. So you've taken UMTS, you convert them, you then apply a threshold to the converted values to select some, and you then transmit some selected converted values on a control channel to a base station if or when they exceed a threshold. And that's all the claim requires. And because it refers to a threshold but makes no reference to comparison between rats, it is clearly generalised out from the second embodiment. And so, my lord, we point out that the patentee has chosen to omit multiple features of the first preferred embodiment, including GSM, including 6 of best, including inter-rat comparisons. So turning over in my skeleton to paragraph 45, we make a number of bullet point submissions on the scope of the claim. First, that the word value appears 7 times, the word format isn't present at all, and we say conversion of value ties in with that line 1 of paragraph 16, where it refers to converted values. Secondly, there's no requirement to do any comparison of converted values with values for the second system, because there's no mention at all of what you do with the second system. And instead, as we say in the third bullet, the comparisons with a threshold value with no limitations to where it comes from. There may even be more than one, because it talks about more than one. There is no
at least one.
So at least one, yes. There's no limitation as to the format in which the converted values are sent, and that is right. There is no reference to the message, and as we point out a little later, there's even no reference to sending them on the SATch. Could be on the FATch for this claim one. There's no reference to sending of any values from the second system, and therefore no mention of sending them all in the same message, or as I said earlier, sharing the envelope. You can send GSM in one message and UMTS in a different message, and the claim doesn't in any way exclude that. The claim is silent as to which rat's way round, so at least this claim you could have GSM to UMTS or UMTS to GSM, which might mean that the format increases the number of bits or decreases the number of bits. But in any event, no claim covers both together. The claim is silent, as I've just pointed out, as to the channel, and so in GSM it's indifferent as to whether you use...
I'd be puzzled by the statement, no claim covers both together. I'm not sure it matters at all, but surely the claim does cover both together. There's no claim which requires both together.
Your Lordship's absolutely right, and I accept that, yes. But there's no limitation. There's no limitation that it's the specific embodiment that the patent is talking about in its preferred embodiment. And lastly, which we'll come to, the claim covers the case where the network takes handover decisions. That means, as my friend explained this morning, it covers network-directed mobile-assisted handover. That is the case where the mobile assists by sending measurements, but the network actually takes the decision on the basis of those measurements as to where to hand over. And the patent confirms that that's the scenario it's addressing. And I can, paragraph 15, line 49, paragraph 17, line 13 are two references if I need that. So there's no definition of the control channel, still less the shape of the report sent on it. The claim is untethered to any reporting format. None is specified for either the first or the second system. In other words, because it's not limited to GSM, it doesn't specify the GSM goes on the GSM message, and it doesn't specify that the UMTS measurements go on a UMTS measurement. And there's no specification of any link between those formats or any correspondence of those formats. We say that the conversion is not referred to as conversion alone, it is referring to conversion of value. And one can't gloss over the reference to value, meaning we say magnitude, i.e. what was done in paragraph 15. As to format, we point out in paragraph 48 at the top of this page that always it was a preference rather than a mandatory requirement. And more overall, we say that Nokia and IPCOM has direct relevance here. The patentee has chosen to put values in its claim, not mention format, all of which was a preferred feature but not a claimed feature. And what appears to have happened is that the claim draftsman chose to base his claim on the second embodiment. Rather than limiting to GSM and UMTS, he generalised out a principle of general application. He therefore left out any reference to GSM format or any format at all, and he left the SATch out of Claim 1 also, to provide an extremely wide claim. Well, as to its width, the judge hit the nail on the head, we say.
Just before you get on to that, am I right in thinking the word value is only used in paragraph 15 in connection with offsets? Otherwise, the word used is information.
I have got it marked. Paragraph 15, information appears
Several.
6 times in my highlighted copy.
Yeah.
The value, paragraph 15 as a whole, we know is concerned with magnitudes rather than formats. Information also pops up in paragraph 14 4 times, and format twice, but always with preference. Information disappears in paragraph 16 and it becomes entirely values. I don't know whether that's helpful to your lordship, but I think it's a comprehensive answer.
Well, you see signal strength value, e.g. in line 1, you also see signal strength information in line 6. So would you agree or dissent with the proposition that information and value are used interchangeably?
I believe that I would submit that they are used interchangeably and synonymously for this purpose. The information, so the information is the magnitude, but it can also, at line 6, it can also be put into the GSM format and therefore given a format as well. It is an oddity that paragraph 15 refers entirely to information. Paragraph 16 switches to value, although, as your lordship pointed out, at line 6 pops up signal strength information, but that's going back to paragraph 15.
And is it your submission that in paragraph 17 the word information is used in contradistinction to format?
That must be right in context, because it's taken UMTS measurement information. It's converting it in this embodiment, taking UMTS information. It's been converted in 15 into the value, and it's also preferably also going to be converted into a format. UMTS measurement information at line 12 must be the UMTS measurement values in their native sense, the raw, unconverted UMTS values. And it's going to convert them both into GSM comparable numbers and then preferably also into a GSM format. This is, we say paragraph 17 is dealing with the described method 100, and therefore the first alternative, the sixth best alternative. Well, I was going to point out paragraph 194 of the judgment, because this is where I think the judge does get to grips ultimately with the scope of the claim, the width of the claim. This is a section when he's going through the so-called Pozzoli analysis, where he's comparing the scope of the claim with a piece of prior art called T-Doc 1145. But the key point I want to draw attention to in 194 is where he's discussing feature D, reporting measured values to the network. He accepts that the prior art discloses that. He accepts it describes a UMTS measurement report which will be triggered if it exceeds a threshold. And then the proposal is that it be sent on the fetch, but that's no distinction over claim 1. Moreover, the report is not a standard GSM measurement report. It's a special UMTS measurement report, but that is no distinction over claim 1 either. And then it's being sent in a different way, but that's no distinction. And then at 195 he picks up converted value, and 196 Satch for what it's worth. But my point here is that he expressly accepts here that Claim 1 is not limited to using the same GSM measurement report, but covers a special UMTS measurement report for the UMTS values, in complete contradistinction to the first preferred embodiment. The anticipation argument failed because there was no conversion of value as he had construed it. But as far as claim scope is concerned, the fact that different messages were sent, or different messages were used for GSM measurements and for UMTS measurements, was not something that the claim excluded. Well, I can make a similar point in a slightly different way. The GSM measurement format used the SATCH, as was common general knowledge. Claim 1 is not limited to the SATCH and plainly covers using the FATCH, for example. And that being so, you can't tie the conversion step in any way to format because you can't tie it to a shared message. Because Claim 1 expressly fails to exclude, or fails to require SATCH, but would include FATCH. Contrast Claim 8. It's contemplating, for example, that the GSM goes on the SATCH as before, and the UMTS goes on a separate message on the FATCH, which is effectively a similar point to his paragraph 194. So the claim doesn't exclude separate measurement reports, separate report formats, and doesn't require sharing a report with both GSM and UMTS values in it. Well, I'm pausing there. That, we say, knocks out Optis's contention on substitutability. The skeleton argument of Optis says that the purpose of conversion is to enable one kind of value to be substituted for another in a message. They call it substitutability. But the claim doesn't require substitutability because it doesn't require anything to be substituted with anything. They pick it up, I'll just give you a look at the references, paragraph 46 and 52 of the Optis's skeleton picks up substitutability in the description, but at 59 and 60 they then elide it into a claim scope itself. We say substitutability is not to be found in the claims because a shared message is not required. So in short, with no template in the claims for the format, format in the description is always a preference rather than a requirement. And formatting is not a claim requirement at all. We agree with the judgment of paragraph 103, where he points out that it makes UMTS value be expressed as if it was a GSM value, even though it's not. That's what's meant in paragraph 15, but in that embodiment it enables the values to be compared. In the scope of the claim, that's not necessary. Well, then going to the judgment itself as to these issues, he turns to formatting paragraph 89. Apple submitted that what was claimed was only conversion of comparability, not anything to do with formatting. That is my position. And the difference between the parties, as I've explained, is that formatting is post-conversion. Conversion at 15, formatting at 16. And as the judge had already held at paragraph 80, the reader wouldn't regard the GSM format as mandatory in the second alternative. At paragraph 91, he gives some reasons, and at paragraph 91, 92, 91, in the middle of 91, he says Apple also argued the claim doesn't require comparisons between GSM measurements and UMTS measurements. That is true, which is why it's right to identify the claim as relating to the second alternative rather than the first. However, this is capable of being taken too far because, contrary to Apple's case, the two alternatives are not as different from one another as Apple contends. Well, with respect to paragraph 80, he had pointed out that even the alternatives in the description don't mandate, the second alternative doesn't mandate a GSM type format. And so paragraphs 91 and 92 are dealing with exemplary rather than limiting requirements in the specification. He'd already supported Apple's position at his paragraph 80. I'm going to come back to 93 because it's quite key to agree though, and I'll deal with it when I've dealt with the law. At paragraph 95, he says he doesn't agree that Apple's submission as regards values refers only to comparability and not to formatting. He alleges that we're taking part on meticulous verbal analysis. With respect, we would say that we're simply taking due care of the teaching. And then he quotes, strikingly, paragraph 15, lines 50 to 51, paragraph 14, line 39, and paragraph 17, line 12. He says where the specification refers to converting into an appropriate GSM measurement format. Well, those latter two are all prefaced by a preference rather than a requirement. So although he says their information is converted to a format, we're still in the preferred embodiment and not within the claim across its full scope. And then the rest, well, your Lordship, I think, sees where I'm heading. All of the rest is premised on his placing far too much reliance on the first embodiment rather than the scope of the claims themselves. We say he's fallen into the error in Nokia and IPCOM of imputing features of the preferred embodiment into the claims. And in paragraph 95, particularly unfortunately, because the very passages that he referred to indicates that features are preferred. And paragraph 101 is where he sort of rounds up. To some extent, Apple's case involves suggesting the specification draws a sharp distinction between format to format change and information to information change. I do not accept that. Well, with respect, the claims do. The preferred embodiment does. The boxes 104 and 106 are separate, and the claims say nothing about format. So, for all those respects, we say that the judge erred. And perhaps most strikingly, it was only paragraph 194 of the judgment that we just looked at, where the judge came to appreciate how much wider the claims are than the preferred embodiment, where the judge applied a completely different distinction. Well, paragraph 194 of the judgment, which we have referred to expressly in the grounds of appeal, is exactly our position. So in the earlier part of the judgment, he'd subconsciously tied his thinking to the preferred embodiment. When he came to write 194, he appreciated the width of the claim, but he didn't then revisit the earlier part of the judgment and appreciate that the claims contain no requirement as to the same message, let alone the same format. Well, and I'm coming on to aggrieved business itself, but if I may just pick up a couple of points from Optis's skeleton argument, because there's what I've been submitting. If your Lordship would be so kind as to take Optis's skeleton and look at paragraph 20 on it's page 5, page 46 of the and really the last two lines are the ones that I take most objection to. They say, due to format interchangeability, all of the possible places for measurements in the report message can potentially be used for reporting a cell from either system. And your Lordship will appreciate there is no the report message. The claim covers entirely separate report messages so that interchangeability never arises. And skipping forward, at paragraph 32, to say 14 also indicates that for GSM, the UMTS measurement is converted to an appropriate GSM format. They've omitted the word preferably. In fairness to them, here, they say at the end of the paragraph, although the conversion is described as preferably occurring, the claims are focused on and limited to the case in which conversion is in fact done. So one needs to be careful what kind of conversion we're talking about there. The conversion is done in the claims of value, not of format. And turning over the page at paragraph 38, second line 2 at the very end, although the word format doesn't appear here, the skilled addressee knows that the converted information is in the GSM format. With respect to when one's talking about the claims, or even the preferred second alternative, the skilled addressee knows that it's a converted value. He does not know that it's preferably in the GSM format. Well, he does know it's preferable, he doesn't know it must be. And well, one has to be careful that the word conversion is sometimes elided into conversion of format without necessarily clearly distinguishing them. Or they come on to substitutability, and I've commented on that. Well, that's the construction of the description, construction of the claims. I now want to come on to aggrieved obviousness itself, which is where all this was headed. It starts in our skeleton at page 21. We draw attention to two specific questions which arise in this case. The first is that what is the purpose of conversion in the claimed invention, and what benefit does it provide, given that no comparisons between the measurements from different rats are required by any claim? So although the purpose of conversion was clear in the first alternative, 6 of the best, the claim doesn't require inter-rat comparisons, and so one might ask, well, why should there be a conversion at all? And secondly, and relatedly, how does conversion, or indeed the other claim features, overcome the problem identified in the patent of lack of signalling capacity? Or if it doesn't solve that problem, what problem does it solve? And more does Lordship will have foreseen, we say they arise from the same underlying problem with the patent.
Is it your submission that failure to solve a problem identified in the specification, is it a ground of invalidity?
No, it's not. But then one might ask, why else is it being done as opposed to being an arbitrary feature? And we say it's an arbitrary feature, as I'll come to, with support of the judge. No, it's not of itself, and the judge, I think, expressly says that. But it is a reasonable question to ask as one reaches this point. The problem with the patent is that it overgeneralises far wider than the description justifies, and it generalises out from the second alternative embodiment, requiring a conversion which is pointless. And again, at the risk of sounding like a broken record, the first alternative required a comparison and therefore necessitated a conversion to ensure that the best could be selected. There's no point in the second alternative or in the claims because no comparisons are required. And the way that the patent achieves the problem that it purports to solve is always with the first alternative. The first alternative solved the signal capacity by shoehorning UMTS measurements into the GSM measurement format, squeeze them in and carry on using exactly the same message as before, which you knew you could use. But the claims aren't tethered to that, not even to a non-stealing channel. The problem in the patent is solved by the much narrower combination of features. That is to say, convert to permit a comparison, pick the 6 best, convert the format, use the existing GSM measurement format, and use the SATC in the way the GSM used it. The claims, by contrast, are much wider and untethered to any comparison requirement, let alone the other requirements, and therefore provide a conversion which has no visible purpose. Or, as far as the law of aggrieved obviousness is concerned, the first thing I can say is that we don't quarrel with the judge's summary at 206 to 209 of the judgment. Given his subsequent findings at 210, which we'll come to, we don't need to dispute any of it. In a nutshell, he puts it at 207. The point of aggrieved, middle of 207, the point of aggrieved obviousness is that if a claim is found to contain an arbitrary limitation in it, then the limitation cannot assist the patentee in defending an obviousness case. That's a very concise summary, but given his subsequent finding at 210.
What do you say about the last sentence? Isn't that kind of important? The claim
the
still
claims,
has to be
yes.
obvious over something in the state of the
Yes,
art.
I'll come to that. There's a point taken by my friend Skeleton, I can answer it. I will in a moment. Yes, but can we just remind ourselves, I'm going to try and summarise aggrieved. It's in the bundles, but I can hope take it quite shortly. Its reasoning went like this. There is an infinite number of theoretically possible chemical compounds. You could try to list them, but the list will be endless. And randomly selecting one compound or a class of compounds without any reason is per se obvious. It doesn't involve an inventive step, it makes no technical contribution. You simply select randomly from an infinite class for no particular purpose. In aggrieved, the patentee claimed a defined class of compounds, and it said there is a purpose. My class of compounds has herbicidal properties. But the problem was that that technical effect, herbicidal, couldn't be shown to work across the entire subclass. It just could be shown to work for some specific compounds within the class. And that being so, the patentee couldn't say that its selection of that class of compounds as a class had a common distinguishing property. And its class as a whole therefore amounted to no more than an arbitrary selection of a group of compounds, some of which were useful, but others of which had no demonstrable purpose. And on that basis, it was held no more inventive than a purely random selection of compounds. It conferred no technical advantage shared by all members of the class, and the claim was refused. Lord, I hope that's a concise but not inaccurate summary of the basic reasoning in aggrieved.
Well, indeed, but what it shows is that the objection in that case was to the breadth of the claim, because your starting point was that selecting a class of compounds was inherently obvious. So they've done something which is inherently obvious unless there's some justification that makes it non-obvious. The justification is, oh, well, these things have herbicidal properties, that's not obvious. But their class extended beyond that which they showed had herbicidal properties. So it's all about breadth of claim.
Absolutely right, but it's now come to be called aggrieved obviousness because the rationale then being that if you've got an arbitrary feature that doesn't contribute by its selection to a useful class, then the claim as a whole fails. What I put it as...
Well, you say that, but you've got to be very careful about it, because there was actually no arbitrary feature in the claim. You can't look at that claim and point to the arbitrary feature. The point is that the entire claim was arbitrary, taken at face value.
That's right. Yes, it's been...
And the reason why it fell was not because, taken at face value, the entire claim was arbitrary. The reason it fell was because the justification for the claim did not equiparate with the breadth of the claim.
Yes, that is another way of looking at the reasoning, but it is that underlying reasoning. Well, I would put it this way, that a patentee can't rely on a curate's egg submission. Parts of it are excellent. The patentee can't say, well, I may have claimed a wide class. Parts of it are excellent because they have herbicidal properties. The problem in that case is that parts of it were not excellent because they had no herbicidal properties, and therefore, if it was no use showing that some members of the claimed class were beneficial, if the class as a whole did not. And the reason for that was the basic premise of patent law, that if anything falling within the claims is obvious, then the claim is invalid, and the patentee has to either amend it down to exclude the obvious material, or cut out those parts that don't provide the technical benefit.
See, on any view, you can't translate the reasoning in Agrevo itself to this case, because you can't possibly say that the claim in this case, taken as a whole, is arbitrary, and the reason why it falls is because the justification doesn't equiparate with the breadth. You just can't run that argument in this case. So you need to identify some narrower principle, or that will apply in a case such as the present.
Well, yes, it's been. I'll come to really the patent. The judge gives me that in paragraph 210. So I'll get to it, but just to look at the law momentarily. I've said I don't quarrel with what the judge said, but the fullest. Agrevo has been applied multiple times in this court in multiple different factual circumstances. We've set out in our skeleton what Mr Justice Kitchen, as he then was, said in Abbott, which is a very concise summary. That's paragraph 102 of our skeleton. But I was going to go to generics and Yader.
Sorry, can I just remind myself of
our skeleton at 102 cites Abbott. Well, just pausing on Abbott, that is a little more refined than the basic argument in Agrevo.
Indeed.
And it's applying the Agrevo principle, but applying it to a feature, a single feature, as opposed to the claim as a whole, which is obvious, and therefore saying that that feature can't.
Well, indeed, but that's why I asked the question.
Yes,
precisely because you have to distinguish between Agrevo itself, where your starting point is something which is inherently obvious, taking the claim at face value, and the more refined principle, as you rightly describe it, where we are looking at something where the claim as a whole is not inherently arbitrary and therefore inherently obvious, but you point to a specific limitation in the claim. You say, well, that limitation is arbitrary.
Yes.
Therefore, we should ignore it. And therefore, when we come to assess obviousness of what's left, that part of it doesn't feature in the analysis.
Absolutely, and that is I accept, is a refinement of Agrevo, unless one took the view, and I'm not going to elaborate as to whether one took the view that the universe of compounds is itself the prior art side starting point. Well, I was going to go to generics and Yader, which is authorities tab 3, because I think that is a fuller exposition of what I've tried in my own inadequate way to summarise. Always safer to go back. This court has applied Agrevo in a number of cases, and indeed in a number of technical fields. I want to pick up tab 3, page 116 of the bundle. And paragraph 39, as with any consideration of obviousness, the technical results or effects must be shared by everything falling in the claim under attack. This falls from the fundamental principle that the extent of the monopoly conferred by a patent must be justified by the technical contribution to the art. If some of the products covered by a claim demonstrate a particular property, but others do not, then the technical problem cannot be formulated by reference to that property. Either the products which don't exhibit the property must be excised from the claim by amendment, or the problem must be formulated by reference to some other, perhaps more mundane technical contribution common to the whole claim. Well, that's what I call the curate's egg point, that parts of it are excellent,
yes,
it's not good enough.
The benefit of my lords, one ought to have some orientation. This comes in the middle of a discussion of the EPO problem and solution approach, which is set out in paragraph 38.
It does, and
that's why, if you look at the EPO jurisprudence, this is all viewed from the prism of obviousness.
Yes.
Whereas I would suggest in this country we have a greater tendency to look at it through the prism of insufficiency, albeit that you can find cases in which it's looked at through this prism as well.
I did look at Akibia, we haven't got it in court, but Akibia, the court below, which I think was your lordship, and this court, reached different conclusions on the facts, but interestingly they both regarded insufficiency and Agrevo obviousness as effectively coming to the same result, applying the same test in different ways. And so I think both judgments actually looked at it on a sufficiency basis as the prime point, and then added that the same result would follow from Agrevo. But I'm on Agrevo because I think it is perhaps the easiest analysis in this case, and the judge has given me the way forward. Well, what I wanted to say about this was that, yes, there is a full context, red highlighted starting at 36. I picked up 39 in particular, but paragraph 40 then goes to Agrevo and sets it out in some detail as to the rationale. It then moves on to another EPO case, John Hopkins. At paragraph 44, we come to it being applied in the English court, in Connor and Angiotech, in Dr. Reddy's, and what ultimately this court held at 49, in I think what is a useful summary here. I'd summarise the position thus far in the following way. Article 56 is in part based on the underlying principle that the scope of the patent monopoly must be justified by the patentee's contribution to the art. If the alleged contribution is a technical effect which is not common to substantially everything covered by a claim, it can't be used to formulate the question. In such circumstances, the claim must either be restricted to the subject matter which makes good the technical contribution, or a different technical solution common to the whole claim must be found. A selection from the prior art which is purely arbitrary and cannot be justified by some useful technical property is likely to be held to be obvious because it does not make a real technical advance. And then 5, 6 and 7 are plausibility points which arise primarily in pharmaceutical chemical cases, less likely to arise in telecoms cases or other areas. Well, your lordship has yourself held in Sandvik that the Agrevo principle can be applied in any field of invention. We've got that in Authorities tab 9, and the lordship held in that one an arbitrary selection from the prior art is not inventive regardless of the field, and that was applying Agrevo into a cutting insert. It's tab 9 of the Authorities bundle, page 344, paragraph 1. Your Lordship in this one had again reviewed Agrivo and the subsequent English court decisions, and then at 185 concluded the principles to be applied in determining whether a claimed invention is obvious are the same regardless of the field of the invention. The application can vary according to the circumstances. An arbitrary selection from the prior art is not inventive regardless of the field, and it apprises particularly in chemical compounds. That your Lordship applied it here to a cutting insert, and subsequently Mr Justice Floyd, as he then was, applied it specifically in a telecoms case in Samsung, which the judge referred to. The judge in this case referred
Sorry, I'm
to.
struggling to understand the relevance of what I said in Sandvik, leaving aside the fact that it was 10 years ago. It might be said the law has moved on a bit since then. But even leaving that aside, I mean, you're not suggesting the present case is one of arbitrary selection from the prior art, are you?
Well, what I'm suggesting is that the judge effectively gave me the starting point at 210. What I've said that we don't quarrel with the judge's discussion of the law, because at 210 of this judgment, he made a finding, which is unchallenged, that if conversion was an arbitrary feature, then I agree with Apple that the claim would be agreevo obvious. And he explains the reason for that. It was because, stripped of the conversion feature, Claim 1 would cover a process in the context of inter-rat handover from GSM to UMTS, in which the phone measures a UMTS value, like RSCP, compares it against the threshold, and sends that UMTS measurement to the GSM network on a control channel if measurement exceeds the threshold. And then the reason for the threshold doesn't matter. The claim also covers a report on any control channel. That process, couched at that level of generality, would be obvious to the skilled person at the priority date.
Yeah, and you say there's no respondent's notice challenging that.
There is no respondent's notice challenging that. And it is a finding of fact. I can show your Lordship in a moment what it's based on, but let's just take it as read for the moment. The judge having held that, if conversion was an arbitrary feature, then I agree with Apple that the claim may be very obvious. So the challenge that I have to meet really is to satisfy that premise of whether conversion is an arbitrary feature. The judge goes on to hold at 211 that he says conversion is not arbitrary. It has the result that it has two beneficial properties, which I'll come to. Lord, we respectfully say he was wrong, and he was wrong because he failed to take account of the claim width, and in respect of the issues of comparability and formatting, he contradicted himself elsewhere in the judgment. We do respectfully say that both are arbitrary, and they provide no technical effect across the full width of the claim. So no matter how good the first preferred embodiment is, the curate's egg, the rest of the claim is far too wide because conversion across the full width is arbitrary. Or then we say it's arbitrary in a nutshell because the claims don't require any comparison to be made. The claims don't require comparison of GSM with UMTS or broadly between two different rats of any description. And they don't require comparison with the GSM threshold, they just require it with a threshold. And the judge himself gave a perfect explanation of why conversion in the phone provides no technical benefit when he addressed the prior art. And we've highlighted the key passage in our skeleton. But just to take this in context, at paragraph 171, let's take 170. Turning to features C and D, Losh does describe comparing measurements with thresholds and only reporting those which exceed the threshold. There is no explicit reference in Losh to do threshold comparison with converted values, and there's no reference to converting alternate measurements into the measurement format of the current MA. And then he rejects Apple's traditional obviousness case paragraph 174. And the reasons that he gives are key to the issue that I'm now discussing. Paragraph 174, as Losh says, one could have the handover decision made by the phone or by the network. A critical problem with Attle's obviousness case is that the idea of comparing values in Losh is disclosed only for the purpose of making handover decisions. To the skilled person, it would be obvious to do that in the phone if the phone was making handover decisions. But in that case, there'd be no reason to send measurement values in the report to the GSM network. So far, so good, and that's not the case we're discussing here. That's phone-directed handover. And then he goes on the other hand, that's 8 lines down. On the other hand, if the skilled person was not considering handover decisions in the phone, they would be considering network-directed mobile-assisted handover. That is the situation that this case is involved. The network decides, the phone reports. Indeed, that's the more attractive option. In that case, it would be obvious to send UMTS measurement information to the network. However, the reference to comparison in Losh would not be understood to have any relevance. There is no reason to make any conversion in the phone for the purpose of comparability. I'm not persuaded, etc. It's only with hindsight to see the reference to understood into one context and seek to turn that into a hint to make interactive measurement comparisons in the phone for a different purpose. In other words, the only obvious way forward from Losh, in the case where the network makes handover decisions, does not involve conversions for the comparability. Comparison with a threshold would be an obvious thing to do to reduce reporting traffic, but while that is part of Claim 1, it still does not involve any conversion. So the judge rejected the traditional obviousness case on conversion on the basis there was no reason to do it in the phone if you were doing network-directed, mobile-assisted handover. And that's precisely the point we make in our Grievo, that conversion does provide no technical advantage in that case, because the claim covers handover decisions in the network. All the systems in issue do. The patent description says so in terms that that's what it covers. And in passing, by reference to Mr. Nicholson's argument, that's precisely why the standards can work using native UMTS values. The native UMTS values are reported in the standards. The judge addressed this also at 201, dealing with the other piece of prior art. The last 4 lines of 201. Let's take middle 201. Second, if the skilled person had decided to follow up TDoc 1145 with a handover decision in the base station, the only obvious way would be to use a special UMTS measurement message. In such a case, there will be no obvious reason based on report formatting to use the GSM format. In other words, no need for conversion. The idea that the phone would convert the UMTS values into a GSM format simply to save the base station some effort is fanciful. The obvious place to make that conversion without hindsight is in the base station. So again, what he's saying is that there was no useful purpose to be made by converting in the phone in a case when the network makes handover decisions. You might as well just send, you might just as well send unconverted values. The conversion provides no useful purpose, it saves no time for the base station, and at 174, when the network is taking the decisions, there's no reason at all to carry out that conversion in the phone. And we say the point is that if there's no comparison required by the claim in the phone, then there's no reason to do conversion, and there's no other benefit that conversion confers. So the judge rejected all those when dealing with the prior art. To save time for the base station is fanciful, and there's no point if the conversion is being done, if the decisions are being done in the network. What seems to have happened is that the draftsman was thinking in terms of the comparison in the first embodiment, He assumed conversion value would be useful and put it in the claims, but it turns out, given the width of the claim, that no comparison is required in the phone and therefore no conversion is necessary. And on that basis, we say conversion is an arbitrary requirement. It confers no technical benefit. It addresses no technical problem. It provides no additional value to the user. And the same point really arises for formatting. On formatting, we say it's not in the claim at all.
Well, just before you get on to formatting,
yes.
It is of course correct that there's no comparison between communication systems in the phone according to the claim, but there is a comparison with the predetermined threshold measurement value.
Well, there is, but that threshold value itself doesn't have to be a converted value. And as we've seen in the standards, there are separate GSM thresholds and UMTS thresholds. If the claim had said, one could probably infer that it would have been sensible in the limited, if you do a conversion in the phone, that you might want to convert the threshold as well. But if there's no need to do the conversion in the phone, there's no need to have a converted threshold. And in the standards in issue, it works perfectly well with separate thresholds for each RAT. The draftsman overlooked any need to qualify the definition of threshold in the claim itself. Well, the formatting is straightforward.
Can I just, before you
yes. Sorry.
Go on to formatting, I'm still slightly puzzled by this argument, because on one view, it could be said to be an argument that the patentee has unnecessarily limited his claim, in that he's put in a requirement of conversion that he need not have put in. He could have made his claim even broader.
Yes, but as the judge says at 210, that will make it obvious.
Right.
It would die. So he's put in conversion, but the feature that he's put in fact, confers no technical benefit. And that's as simple as it is. So I have my starting point in the judgment itself. I'll come on to where he gets that from in a moment. Yes, the Lordship is right. He's put in conversion. If he hadn't put in conversion, the claim is obvious on its face.
Yeah.
Because as the judge said, thresholds are obvious to reduce traffic. And everything else is just straightforward measurement reporting, which was common general knowledge from GSM. And that's why the judge expressed himself in the way he did at 210. On formatting, we say first of all it's not in the claim at all, but if it was, it would also be pointless, because as the judge recognised, the paragraph 194 that we looked at, the one cited in our grounds of appeal, the claims cover situation where separate messages with separate formats are sent separately. On that basis, there's no point in stipulating format, because a need for substitutability never arises. So I would say that the Optis fall into the same error as all the Agrevo and the Agrevo subsequent authorities. They rely on a subclass rather than looking at the whole width of the claim. I was going to pick up the two key paragraphs in the judgment where he identifies the benefits that he believes are relevant. The first one is paragraph 93. In my judgment, the skilled reader would understand the pattern as a whole to refer to conversion as a process with both aspects, which purpose is to render the UMTS measurement in a form comparable with a GSM measurement and expressed in a GSM measurement format. The former makes it useful for handover decisions, and the latter helps send it on the SATch in a non-stealing mode. The reader would, etc. But as far as those two purposes are concerned, because the claim is not limited to require any comparison between RATs, the comparability requirement is pointless. And as far as format is concerned, the claims don't require a GSM measurement format or using the same message for reports in different RATs, and therefore the expressing in a GSM measurement format is also pointless across the width of the claim. Well, he comes back to this at paragraph 157, which is his other key paragraph in his benefits. Halfway down, well, 157, 5 lines from the bottom, there are 2 benefits. The first arises because the conversion means that the values are directly comparable between the 2 systems, but the claim doesn't require that. This makes them useful for making handover decisions. Well, no, because the network can do that. And it also allows the comparison to be made between the 2 systems to decide which measurements to report, but there's no decision required in the claim. The second benefit means the values will be treated alike where format matters, such as by filling up space in the measurement report. But the claim contemplates different measurement reports, and in its broadest form, even on different channels. So there's no reference to sharing a measurement report, and so the second benefit is also, in fact, no benefit at all. Well, we therefore respectfully say, in a nutshell, that the premise proposed in 210, if conversion was an arbitrary feature, I agree that the claim will be agreed by obvious. The premise is satisfied and the claim falls. The features of the claims aren't sufficient to achieve the patentee's object or any other identified object. The problem that the patent is talking about is only solved in GSM by converting values, comparing the mobile, selecting 6 of the best, putting UMTS into GSM format and sending it in a GSM message and using the SAT for that. And the claims omit all of that. They are, strikingly, the first alternative is the one that meets the patentee's object, but he's claimed the second alternative and broadened it out too far. Well, and just picking up, finally, a complaint made in the Optis skeleton, they say correctly, and we accept, that for aggrevo obviousness to run, one still needs a starting point. I've got 2 answers to that. First of all, I have a finding of fact by the judge himself at 210 that it would be obvious if conversion was arbitrary. And we cited that express paragraph on the grounds of appeal, paragraph 7, and there's no respondent's notice. And it's supported by an express finding that thresholds were obvious. That's paragraph 175 of the judgment. Well, the second reason is that for that finding at judgment 210, the judge didn't identify expressly what the process to which he was referring was, but he clearly had in mind the cited prior art. And indeed, one doesn't have to look very far for that. The prior art citation, T-Doc 1145, had all of those elements, and the judge ticks them all off at paragraph 187 onwards. He does a comparison of this piece of prior art with the claim. 187 discloses feature A. 188 feature B, there's no disclosure of conversion. We accept that and we say it's arbitrary. And then he deals with that. At 192, he says concerning feature C, there's a clear disclosure of comparison with a threshold, but not with converted values. And at 194, he says that feature D is disclosed because it doesn't matter that it's in different reports. But he makes the point again on 195, no conversion. And 196, in relation to claim 8, the document does contemplate sending on the SAT. So the only missing feature was the conversion step. But if that's arbitrary, then there's nothing left. And well, as to that, the fact that it's a left T-Doc 1145 comes as no surprise to Optis, because their own skeleton cites our pleading of Agrevo in relation to T.1145. It's their skeleton paragraph 98. And they're wrong to say that we've dropped the prior art. What we have not pursued is a conventional obviousness case. And the reason we don't pursue what I'll call conventional obviousness is because we don't now contend that conversion as properly construed at judgment paragraph 103 would be obvious. But we do instead say that it's arbitrary. And we can and do say that judgment 210 is actually T.1145, which discloses every other feature and supports the unchallenged finding at 210. It doesn't matter, but we've pleaded out Agrevo in our grounds of invalidity and in our statement of case of validity, including the passage my friend quotes. And so, or then finally, as for the subclaims, they all fall with Claim 1 for the same reasons. Claim 1 isn't limited to a class sharing either the benefits identified by the judge, nor are any of the other claims. Indeed, they highlight the width of Claim 1. Such was already common general knowledge and is disclosed, and the premise, the patent starts with the premise there's no space, but only tells you how to solve it in a combination in the first alternative of 16, which isn't claimed. And the judgment at 212 and 213 draw no distinction between the claims, and there's no respondent's notice on that. Well, 213 is a strange paragraph. Claim 1 covers a case in which a converted measurement whose passing the threshold is reported on a stealing channel, but rather factual and event-driven basis. If someone did set up a system which worked in that way, they'd be doing something generally enabled by the disclosure in the patent. So in respect, that simply says if you do something as broad as Claim 1, then you're doing something in Claim 1. And owing to their use of converted values, well, that's in the premise. Paragraph 213 really is pulls itself up by its own bootstraps. So
what relevance does that have for present?
Well, it simply says that the judge in this passage effectively drew no distinction between any of the claims, and it's in the context of Biogen, but he says as with Agrevo. It's very difficult to understand what he's saying is enabled in the paragraph that we've looked at. So, well, we do say that overall, then, the judge erred in principle by failing to appreciate that the benefits he identified had to apply across the full scope of the claims. And then, when applying that law, he failed to appreciate that the claims covered use of separate messages and required no inter-ad comparison. But the only benefits he identified only arose where comparisons were made in the mobile and a mixture of measurements was sent to the same message. And that's a very limited subclass of this very wide claim.
I don't think we need to get into 210 and 212. I mean, as I understand it, your point is actually a slightly different one, namely that when you get to the subclaims, your case is the same because conversion is a feature of the subclaims because it's a feature of Claim 1, and you're still relying on the TDOC. And there's nothing in the subclaims which saves them from the underlying obviousness case.
Exactly. Because such was common general knowledge already.
Yeah.
Exactly. And I think we said that in the skeleton.
Yeah.
But it's saying, Lord, unless I can help further, those are the points we make. The judge has really self-contradicted himself, dealing with the prior art and then dealing with validity. When one looks at the way he deals with validity, it really undermines his case on the benefits that he purported to identify. We say these claims are all invalid because conversion is an arbitrary feature.
Thank you very much. Mr Chaxfield.
My lords, I don't know if my lords might find it convenient to rise for 5 minutes just for the shorthand writing and also while I do a few removals, or
Yes, as a matter of fact, I hadn't thought about it. Normally, we do get requests for breaks for shorthand writers. We haven't, so far as I know, had one in this case, but I'm sure they would appreciate it, and in any event, there's obviously a good reason. So we'll rise for a few moments.
Excuse me, do you want me to move this microphone for you there?
It's still being recorded on the microphone.
Oh, yes.
It's just be on the video for the rest of the day.
Let's see if... Am I bothered?
It's something familiar with the YouTube stuff.
Doubt it. This viewing figures get into double figures, I should be amazed. This is very much specialist.
Well, there'll be all this.
Global patent influence.
There'll be all those past students seeing how it's done. What they're letting themselves in for.
People are saying save yourself while there's still time.
Do you remember years ago, Brendan appeared on Warby, the comedy program? They had a skit about big planning. And this used to come on.
It's all right, we're not saying anything. We're influencers.
All right.
Mr Justice.
May it please you, my lords. I propose to address the court on the following matters in this order, which follows the order in my skeleton argument. So, a short introduction to the technology and in particular to the issue of encoding or notating values. That slightly gives me the opportunity for a moment of self-flagellation because my skeleton talks about annotating and notating. Annotating and rather than notating, which is obviously wrong, but I don't think, I hope, confusing. The patent and construction, which is obviously a core issue, then infringement and then aggrevo. I was quite surprised by the very tail end of my learned friend's submissions about the role of T.1145 in his case, given that the judge found that this is a document that the skilled person wouldn't take forward at all, and then Oberter expressed the view that he doubted that it was obvious to use the SACH, which is obviously the subject matter of claims 8 and 16, in the light of that document. I'll obviously return to that. Subject to that, there are no longer any attacks on the claims for obviousness or lack of novelty over the prior art. Obviously, it's said that the conversion integer is not always useful, but it's not suggested that it is other than novel and inventive. Nor is any allegation of added matter. Now that is an objection that arises where a claim is generalised, or at least in certain, one of the circumstances where it arises, whereas a claim is generalised beyond what a skilled person would understand from reading the application for the patent. And nor anymore is there any allegation that the claims are insufficient. Now, as your lordships may have picked up from my skeleton argument, this patent has previously been litigated in the UK to first instance level and in Germany, where it's gone on appeal both on the infringement in the infringement courts and in the validity courts. In each case, Optis succeeded on validity and infringement, and the courts have adopted a construction which is the same as that adopted by, as he was then, Mr Justice Birss, now Lord Justice Birss, in this decision. I don't propose to go into the details of these, but at the end of my submissions I will give your lordship some references, just so you can take those into account if that assists. Now, just picking up one thing from this morning, I do express a word of warning in respect to my learned friend Mr Nicholson's submissions on essentiality, and in particular the way he advanced his argument on the comparability which is shown by the comparison which occurs at level 4 in the standard. I am a little, I'm afraid, somewhat unclear as to exactly what my learned friend's case is there, and I think it takes one of two forms. I think he accepts that there is a rough and ready comparison that occurs at that level, and hence a rough and ready level of comparability. But at times he appeared to veer towards saying that the level 4 comparison implied no comparability at all, and it's just an arbitrary way of filling the last few cells, as he puts it, in the report.
Well, his overriding point is there's no conversion. So it depends what you mean by comparability. He's focusing his argument, as I understand it, on the words of the claim, and the word in the claim is not comparable, it's convert.
Indeed. But one of the aspects of comparability we'll come on to, sorry, of conversion we will come on to, is this comparability, and obviously I'll address your lordships on that at some length. But what I wanted to point out now is that his first point is new. The way he puts it as a rough and ready comparison. But as I will come on to show you, both his expert and the standard itself describe it as a useful comparison. That's what his expert says, or in the standard to identify the best cells. So indeed, in his closing at trial, he stated the patent himself only required a rough and ready, or as they put it then, a good enough conversion, to provide a useful comparison for the purpose of handover. Now, the second way that I detect it might be put, namely that the comparison is arbitrary, that's completely new. It was, in fact, argued in the original Huawei and Samsung case and rejected by the judge in that case, but it was never run here. Now, what the judge did here was, in fact, just an entirely conventional consideration of the evidence, and I will show you this. But I just do want to flag now the newness of these 2 points in particular. Now that takes me to the technical background. This patent concerns a more flexible and efficient way of sending measurement reports from one telecommunications technology to the network using a different telecommunication technology. Now this is flexible because the same signalling space in the message can be allocated to whichever measurements from whichever technology are best reported. You do not need different messages or different message spaces for different technologies, which gives efficiencies on the air interface. If you had fixed allocations, on the other hand, which was the prior art, some reporting spaces may be left empty if there are not enough good cells for one technology, whilst other good or useful measurements of the second technology may just be discarded. It's efficient, both for the efficiencies on the air interface that I've just mentioned, and also because the measurements from the two systems are presented from start to finish within the system on the same scale. And by that I mean they can be directly compared to work out which is the better. This makes handover decisions...
Sorry, why is direct comparison of any relevance to the claim? There's no comparison between systems within the claim.
Well, I'll come to that. So this makes handover decisions within the network easier, and there's evidence on this, and I'll show you this in a few minutes, my lord. And it provides a means for sensible decisions to be taken on what to report within the phone, whether by reference to the cells, by comparing to the cells of the other telecommunications directly, or via a threshold set on the same scale as that other telecommunication technology. And again, I'll show you this shortly. Now, the patent has both method claims, which are claims 1 to 8, and device claims, which are 9 to 16. Of the subsidiary claims, it's likely only that claims 8 and 16, which relate to the SACH, may need some separate discussion. My learned friend this morning, Mr Nicholson, raised the question as to whether the SACH, the reference to the SACH implied that GSM was the system in question, and he floated the idea that it might not, but the judge found at 17 that the SACH is a GSM control channel. Now, the core of the invention is the converting of the claims. As the judge says at 93 of the judgment, which we will come on to shortly, the conversion of the patent is such that it puts the UMTS measurement in a form which has both the same format as the GSM measurements use and which are comparable with those GSM measurements. So although the measurements are of different things, they are encoded such that the better number means the better connection. So what this means is the patent has as a key focus questions of the manner in which measured things are notated or encoded. Now I just want to consider that a little more, if I may. Fundamentally, the words we use to communicate, or the manner in which we describe measured physical things, are just matters of convention. So a banana is only described by the word banana because we have a linguistic convention that the long yellow fruit is called a banana. Had in times long ago we agreed instead to use the word cucumber for the long yellow fruit on the tree, then bananas would be cucumbers and we'd all be happy with that. In a sense, Humpty Dumpty had it almost right in what he said in Lewis Carroll's Through the Looking Glass. Just a slightly more democratised view of that. Words just mean what we all understand them to mean. Now the same is true for a measurement of any particular physical thing. We describe it in ways which are convenient and which make sense because they correspond to an agreed convention between the speaker and the listener. So, as I mentioned in my skeleton at paragraph 8, if I say that a measured RX lev, which is in fact an electromagnetic oscillation, is minus 106.5 decibel milliwatts, that is just a convention which only makes sense because the user knows how though that phrase minus 106.5 decibel milliwatts relates to a real world phenomenon. I can also describe the same measured thing in 6 bits, say 000100. And as long as the listener knows the convention I'm using, then they will understand what those 6 bits 000100 mean. And I could also call 000100 in human readable decimal terms. In each case, the listener understands what is being conveyed. And whilst it's common to say that, for example, 000100 is minus 106.5 decibel milliwatts, in fact, it's more accurate to say they both describe the same underlying physical thing, each in accordance with their own convention. Now, as a judge
dissent from the discussion that I had with Mr. Birkle about the difference between the property which is being measured and the scale by which you measure it and the method of measurement. So taking the temporary example as discussed, one distinction is between using a scale of Fahrenheit and a scale of Celsius. But you could use those two scales with the same method of measurement of temperature, e.g. a mercury thermometer, but equally you could measure either or both by different measurement methods, and he gave the example of the thermocouple.
Yes, well, can I just, I'm going to come on to the centigrade and Fahrenheit, and then in fact I've got a note to address the question, that exact question my Lord raised with my learned friend at the end of this little section. If I could take it stepwise.
All right.
With that. So the judge also comments in 46 of the judgment that an encoding scheme can be entirely arbitrary, provided both the sender and the recipient know what the rules mean. So you could agree upon the system where the lowest level of the physical thing is called aardvark, and then zebra, and then the next one's called Christmas tree, or whatever. As long as both sides know what the convention is, that works. But that does have the disadvantage in that it's not so easy to compare the different measurements, as there's no direct link between the encoding used and whether that measurement is higher or lower than some other measurement. There's no obvious way of saying Christmas tree is better than rabbit, other than going through the process of looking it up. Whereas if you encode in 7 versus 6, one knows that 7 is bigger than 6. And you could even create an arbitrary scheme using numbers if you wish to. 1 could be somewhere in the middle, 2 could be at the top, 3 could be near the bottom or wherever. Now that takes us to the question of comparability. If you have a logical, say, numeric scheme, then everyone knows that the higher encoded value represents a higher underlying physical thing. It could be vice versa. Higher could mean less good, but it doesn't really matter. So the encoding has the advantage here of not only indicating the nature of the physical measurement, but also making it easy to compare the measurements. And where one has 2 physical things being measured and 2 sets of schemes, it doesn't necessarily follow that the schemes interrelate in a particular way. There's no reason why the encoding of one value in one system necessarily has to correspond to the encoding of another value in a different system. Now this is what the judge discusses in 47 and 48 of the judgment, which is part of the CGK section. And if I could ask your lordships just to read that to yourselves. So that takes us to the Fahrenheit and centigrade example, which is found on page 3 of my skeleton argument. And if I could, it's probably quickest if I just ask your lordships to remind yourself of what we say in paragraph 11 underneath the table. So the point here is that in the case of the middle Fahrenheit encoding, there is no relationship between that encoding and the centigrade column on the left-hand side. You can't tell just by looking at the encoded numbers as 12 or 17 whether a Fahrenheit measurement is hotter or colder than a centigrade measurement. Now, my learned friend Mr Nicholson this morning submitted that there was just an offset here. But actually, well, two comments on that. First, it shows they're not comparable. You have to do more in order to make a comparison. And secondly, there isn't an offset. They don't actually line up in a consistent way. So at the bottom, Fahrenheit is colder than the corresponding centigrade. So a number 1 for Fahrenheit is colder in absolute terms than the number 1 for centigrade. At the top, Fahrenheit is hotter, and somewhere in the middle it's around 9 or 10 or 11. They cross over. But by encoding Fahrenheit in the manner shown in the right-hand column, the two become directly comparable, such you can tell which is the hotter of two measurements just by looking at the encoded numbers. You don't have to actually know what measurement those numbers relate to in order to work out which is hotter. You can just look at the encoding. Now this is a little bit different from what the patent is about, because the patent concerns measurements of physically different things. Whereas temperature, fundamentally, you're looking at the same thing, thermodynamic activity expressed in different ways. Although it does make the basic point. Now, as to my Lord Justice Arnold's question about RSCP and RxLev and the similarities or not between them, the point is that they are similar things, but in each case, the phone is measuring the received power level or the received code power level as a proxy to try and determine the quality of the potential connection that would exist if a connection was made. And the quality of that connection will in turn depend on the details of each system. So they aren't, while they're related, they're not the same. And as I'm going to come to show you later, the standard matches up RxLev measurements with RSCP measurements, which are 5 decibel milliwatts weaker. Or to put that another way, you get a better connection with an RSCP measurement of a particular given value, which is why you can then treat them as if they were 5 decibel milliwatts offset. Now, I hope that addresses my Lord Justice Arnold's question.
Well, it's helpful so far. Let's see how we go.
Well, I was going to then turn to the patent itself. So, we addressed the patent in some detail in paragraphs 14 to 69 of our skeleton. But after introduction, in my oral submissions, I'm going to focus on the key paragraphs at 14 to 17. Now, the patent and the claims concern a method for conveying measurement information from a mobile to a network, and mobile devices which are able to perform that method, have the components to perform that method. The basic thrust of the patent is that it teaches that measurements from one system should be expressed in a form so that they can be treated for the relevant purposes as if they were measurements for the other system, enabling them to be reported and used accordingly. So the core of the invention is the idea that measurements of the first system should be expressed in such a way that they have the same format as the second system and they're on the same scale as the second system. As such, measurements in each system can be treated interchangeably as regards their format. And for example, of particular relevance, space in a reporting message can be used interchangeably by either. Now, I refer to this by the perhaps slightly inelegant term of format substitutability. What that's to highlight is they can be substituted one for the other in the reporting message by reason of their matching formats. And also they can be compared interchangeably as regards their scale. No matter which system is being considered, the higher value indicates the better connection. And this is so even though the things to be reported, RX11, RSCP, are measurements of physically different things, and we've discussed that. Now this is exactly as the judge held in 93 of his judgment, which is an important paragraph, because this is where he summarises, and we submit correctly, what the skilled person reading the patent as a whole understands conversion to mean. Its purpose. Its purpose is to render the UMTS measurements in a form both comparable with a GSM measurement and two, expressed in a GSM measurement format. And then he says the former makes it useful for handover decisions, and the latter helps send it on the SATCH in a non-stealing mode. Now my learned friend has referred repeatedly to paragraph 103 and says 103 is where the judge construes conversion. He's wrong there. In 103, as the title says, the judge is considering one of the two aspects of the converted values. Now, the conversion of the claim provides a number of benefits. And can I take my lords to paragraph 157 of the judgment and ask you just to read that, please? So the judge identifies conversions having two benefits, although in fact the first of these has two aspects, and he goes on to identify those two aspects in that paragraph. So first, the converted values are directly comparable between the two systems. This makes the converted values useful for handover decisions in the network. And so I'm just finding the evidence in that. If I can take here, sorry, my lord has mentioned the evidence. There's no appeal in respect to these, but if I can take you to the cross-examination of Mr. Simmons, it's in the supplemental bundle at tab 15, at page 244 of the bundle. It's the transcript at 360. Just to put it in its proper context, if I could ask my lords to look at 360 line 2, down to 361 line 8. It's really just the last 5 lines on 361, but I don't want to be accused of not putting it in context. So this is my learned friend's expert, and he agrees that having things on this common scale makes it easier to do handover decisions in the network.
This is discussing the first alternative in the preferred embodiment.
Yeah, indeed, but the point is at the end of that, he accepts, as the judge finds in the judgment, that having things on a common scale makes things easier to do the conversion, to do the handover decision in the network. And that makes sense, because the network is receiving floods of these measurements every second, and just having them comparable to start with, because they're on the same scale, makes the handover decision easier. The judge finds, he makes this finding at several points in the judgment, and that's not appealed. Now, secondly, having the values directly comparable allows a comparison to be made between the two systems in the phone to decide which measurements to report. And that is true whether the comparison on the phone is between cells of different rats directly, or is between cells of one rat and a threshold set on the same scale in another rat. Now you can see this from reading from 157 we were just looking at to 82 of the judgment.
But how is a comparison between the two systems in the phone relevant to the claim? Because that's not a feature of the claim.
Well, the threshold is a feature of the claim. There are a number of points there, my lord. Within the phone, the judge finds that there are benefits in having everything on this common scale. And that, again, is not surprising because it gives simplicity in the whole system. My daughter's best friend comes from a bilingual house where they speak English and Portuguese. In the long term, I'm sure that's hugely advantageous for her, but it does lead to a more complex system of communication within their home. So it gives you the benefit of simplicity in the system. It also gives you, there's also the additional fact that the claim doesn't rule out comparing UMTS measurements with GSM measurements directly. It doesn't require it, but it certainly doesn't exclude it. Now, if I can show you some evidence, again, Mr. Thomas in his evidence this is in supplemental tab 7, page 184 of the bundle. His view, which he expresses in paragraph 70, and it's the second half of it, it's where he says 7 lines down, he said, I would also add in respect. He says that there's the same benefit in the phone, whether or not you're comparing measurements directly or you're comparing to a threshold which is on a common basis.
Sorry, which report are we in?
Sorry, my lord.
Thomas 1 or Thomas?
It is Thomas 2. It's in tab 7. It's page 184 of the bundle and paragraph 70.
Thank you.
Sorry, can I just understand that? Is he assuming that it's a GSM threshold?
It's not a GSM threshold. I'll come on to this, but the threshold is set on a common scale with GSM, and you know that because the thing that's being compared with it itself is on the same scale as GSM. So it's not a threshold. That's what so when he refers to a GSM threshold, he's talking about a threshold on a particular scale.
Yeah.
And that's an issue I'm going to come on to because my learned friends try to sort of blur that, but the patent is clear what's been talked about.
Yes, I see.
So what this is about is simplicity and having everything. Everything speaks Portuguese rather than trying to be bilingual. So I know all that analogies are bad, and that's probably an awful one, but I think it makes the point. And that's what he's saying here. He's saying it doesn't make a difference whether you're using a common threshold. And the way it was often referred to at trial was that the threshold was really just like comparing it to a notional GSM base station. Instead of saying is it better than the actual one, just saying is it better than a GSM base station of this particular level or characteristic. Now, and as I've already said, your Lordship will also appreciate that where a threshold is used, that doesn't exclude the phone from also making decisions based on comparisons of cells directly as well. It's not a requirement of the claim, but it's not excluded. And that's one of the points we make in paragraph 106 of our skeleton. Now, so those are the two aspects of the first benefit the judge alludes to, the utility on the phone and the utility in the handover decision in the network of having everything on a common scale. The second benefit is that of format, which allows the values to be treated alike where format matters, and in particular as to format substitutability, as I've described it. Now, as the judge says at the end of paragraph 157 of his judgment, these advantages do show why conversion is a critical aspect of the inventive concept of the claim. Now, with that, I propose to turn to the patent itself, which is in supplemental tab 1. Now, I'm not proposing, unless my lords have any particular questions, to go through the technical field or the description of the related art in paragraphs 1 to 4. And I'm going to come back to paragraphs 5 to 8 at the end. And I'm going to go through this in order, in a little more detail, to pull out the points, some of which my learned friends have rather skirted over. So 9 introduces the figures, and 10 emphasises that the invention and its advantages are best understood by reference to those figures. Paragraph 12 introduces figure 1, which your lordships may have seen on page 8 of the patent. And the hardware doesn't really matter. But if I could pick up the text in paragraph 13 at line 30, where it states a mobile terminal, line 30, a mobile terminal 22 operating in a GSM cell is capable of making UMTS measurements related to the UMTS cell and conveying them in measurement reports to the GSM BSC in measurement reports on the SATS for handover decisions. Notably, the UMTS measurement information being reported is different from the typical GSM measurement information being reported. So it's introducing the idea that the measurement information from the two cells is different. Now, 14, the first two sentences set out the differences between the measurements. But if I can pick it up at line 38, it says, consequently, in order for a mobile station 22 to convey UMTS and measurement information to a GSM BSC, e.g. for handover purposes, the UMTS measurement information is preferably converted to an appropriate GSM measurement format. As such, in accordance with the preferred embodiment of the present invention, an exemplary method that can be used for an MS for converting the UMTS measurement information to a GSM measurement information format is described below as with respect to figure 2. So you notice 3 things here. First, this is where the concept of conversion is introduced. Now, it is said by my learned friend only to be preferable. But of course, the claims are addressing the scenario where conversion is used. So my learned friend makes a big play, for example, in 22 of his skeleton, about the fact the judge missed out the word preferable here. But there's nothing in that, because the claims are concerned with that context. The second point in my submission to note is that the purpose is for reporting the UMTS measurement information to the GSM base station. And then thirdly, accordingly, the conversion is explicitly described twice as being to a GSM measurement format. Now, as we'll see, and it's common ground, and my lords have seen, there is a comparability aspect as well, and it's a common ground that is part of conversion. But what you see here is that format, it is format which from the outset is emphasised by the patent. And what's more, it states here that an exemplary method for converting format is described in figure 2, and figure 2 is described in 15. And my learned friend submitted to your lordships a couple of times today that 15 is conversion, 16 is format. That's what he said towards the end of his submissions. But it just shows you this is wrong. Figure 2, which is what paragraph 15 is all about, is a conversion to the GSM format. Now, 15, the first sentence introduces the method which is designated 100. And as my Lord Justice Arnold picked up in a slightly different context, 100 is the whole thing. In step 102A, the mobile retrieves UMTS information for reporting via GSM. And it says it can, in step 102B, also retrieve GSM signal strength information. Now, note the reason why step 102A is mandatory, the mobile station receives, and 102B is not mandatory because it says it can also receive. That's because you don't need step 102B in the alternative version of step 106, where you're comparing with a threshold. What this shows you is that throughout this part of the document, the patentee has both of those versions of 106 in mind. That takes us to 104, which is important. And here the mobile converts the UMTS measurement information into an appropriate GSM signal strength information, which can be used by the GSM base station for making handover decisions. And there's 2 points here. First, although there's no mention of format in this sentence, we've already seen from the final sentence of 14 that this whole thing is about converting UMTS information to a GSM format. And secondly, this converted information, which can be used in the GSM base station, this can be used in the GSM base station for handover decisions. And the experts all agreed that the word appropriate would be understood as referring to its utility for making those decisions, and the judge refers to that at 63. Now, at line 50, we then come to the example, which is given in terms of the relationship between RxLev and RSCP. It's only exemplary, but it does show the relationship between RxLev being a value in decibel milliwatts and RSCP also in decibel milliwatts, and you see that at line 56, with an offset. And it's discussing the relationship between those two sets of values. Now, firstly, this serves to underline that the result of the conversion should be comparability between those two classes of values. And I'm going to come on to this more later, but just to pick up something my learned friend said this morning, one of the flaws in my learned friend, this is Mr. Nicholson's case, when he talks about value conversion, words not appearing in the claim as such, it is wrong. It's because he presented that argument to your lordships based on comparing the encoded value for RSCP in UMTS with the encoded value of RSCP encoded for GSM. The patent is talking about comparing the measurements for RxLev and RSCP. There are a number of other problems with this approach, but I just wanted to pick up on that one now. And if I may, at this point, could I pick up 2 paragraphs in the judgment? It's paragraphs 103 and 104. So we've seen 103 previously, which sets out the nature and the purpose of the comparability aspect. In 104, the judge finds, and this is not challenged on appeal, that the skilled person would understand that information from different sources could be made comparable by a process of encoding and mapping to an appropriate scale, rather than using a direct formula of the type in the claim. Sorry, in the specification, not in the claim. Now that takes us to 106 in the patent, which is at the top of page 4, paragraph 16. And here it says, at step 106, the mobile station compares the converted UMTS signal strength values derived from 104 with a set of stored GSM signal strength values derived from 102B. The mobile station then retrieves a predetermined number, e.g. 6, and I'll skip the brackets, of the best measurement values from step 106 to be reported in a measurement report to the GSM BSC. Now, it's common ground, and my learned friends have both said this morning, that, at least in this context, the conversion is one which provides values which are both comparable and exhibit format substitutability. But there are 4 other points to pick up on this. First, step 106 is not the conversion step. We've seen that's 104. Second, step 106 is not the sending step. We'll see in a moment. That's step 108.
Well, you say that, but of course the diagram says the opposite.
It does. I think the problem with the diagram is it's trying to fit a lot more text into a small box, and therefore what it really is meaning is for sending in the standard GSM message.
It says and send.
It does. I completely accept. Well, the words are there, my lord. I'm not going to submit they're not. But what this is about, and you get the fuller description in the text. In the text, it specifically says, and this is at line 4, the values to be reported. So there is an inconsistency there. I accept. But what that highlights, and this is my third point, is that step 106 is a selection step. That's certainly the absolute thrust of it. It's deciding what is to be reported. Now, the fourth point is the linguistic point about values. And my Lord Justice Arnold was asking a few questions about that. Now, we addressed this in paragraph 44 of our skeleton. And if I could ask you to read that. So it's page 10, paragraph 44, page 10. So here we see the word values is being used, as between these two paragraphs, in a manner which is synonymous with measurement information generally. And it's also been used in a context which, and here it's in common ground for first alternative 106, involves a conversion with both format and value aspects. So as you'll obviously appreciate, the reason this matters, my learned friend seeks to suggest that the use of the word values in the claim is inapposite to mean a conversion which has any format aspect. This is a really significant part of his construction argument. But this part of the patent makes clear that his submission is just wrong. And the judge made findings relevant to this in 98 of the judgment as well. That's page, I think 87 of the bundle. I'm afraid mine is loose, but I believe it's 87. So you see there says that there's no reason based on specification of the reader to attribute any particular significance to the use of the word value as a way of drawing a distinction in measurement information and the format which is expressed. Terms apt to refer to both, and then he refers to, similar to the way that RxLev can mean the measurement or the formatted number. They are both values for RxLev, as the skilled person understands. And when you say the skilled person understands, what he's really getting at is the last 4 lines of paragraph 46, which is part of the common general knowledge. section at the end. So the take-home point here is that in this part of the patent, the term measurement values is used synonymously with measurement information. And it does so in a context of conversion which everyone agrees has both format and value aspects. Or rather, the result of the conversion has format and value aspects. Now, if I could go back to 16 of the patent, and takes us to step 108. It says, step 108, for this exemplar embodiment, the MS sends a GSM type measurement report for receipt at the BSC on the GSM SATch over the radio air interface. A GSM type measurement report can include signal strength information about UMTS neighbouring cells. So we see that it is a GSM type measurement report that's sent, which can contain signal strength information for UMTS cells. Now, this makes it clear that the result from step 106 is sent in a GSM type message. And as a consequence, format substitutability is a necessary part of this.
But that's precisely because in this particular embodiment, it's a GSM type measurement report, but of course the claim is not so limited.
No, and obviously I'll come on to address them.
So in the claim it could be a UMTS type measurement report, in which case there's no need to convert it.
Obviously I'll come on to address that. That's my then friend's big hurrah, as it were. But just working through, if I can just continue through the patent, that takes us to the alternative version of 106. Where alternatively at step 106, and obviously I stress that it says 106 here, not anything else, not anything more. Instead of comparing the converted UMTS measurement values with the GSM measurement values, the MS can convert each stored measurement value to an appropriate GSM signal strength value, so I lost my place, and select each converted UMTS measurement value that exceeds a predetermined signal strength threshold for reporting to the GSM BSC. So it's not limited to a GSM threshold in the sense of a threshold that's also applied to GSM cells, but it is a threshold which is on the scale of the converted UMTS values, and ergo on a GSM scale. And that's just to make good the point that I touched on with my Lord Justice Newey a few minutes ago. Now, I draw three particular points in this. Firstly, it's described as just being a substitute for step 106, not any of the other steps. Related to this, it states that, sorry, I think I've just misspoken completely. Let me start again. It's described as being a substitute for step 106, not any of the other steps. Secondly, it's still a selection step, and it uses the words for reporting to the GSM BSC. And in my submission, as a judge held, the reporting step remains step 108, which, as we've seen, uses a GSM type report. And thirdly, the conversion step is still step 104, which we looked at in paragraph 15, and in respect to which is common ground that in the context of method 100 as a whole, including the first embodiment, that's a conversion which results in values which have both the comparability and the format substitutability characteristics. So Apple's case on the alternative step 106 is inconsistent with step 108 and step 104. And this is what the judge is, and more, which I'll come back to in a moment, but this is what the judge is addressing in paragraphs 96 and 97 of the judgment. Sorry, it's 96. It's 86 and 87 of the bundle.
I mentioned we've reached a quarter past, so when there's a convenient moment.
My lord, I'm about to start on for 17, so now is the
I wondered whether that was the case. So let's stop there, and we'll start again at 10 in the morning.
Court rise.